This is Smith Dominguez, and we are doing a small estate and business planning workshop. A little bit about us. I'm Alexia Dominguez, and this is my partner, Anya Smith. We're a small law firm located in Raleigh. We focus on meeting you anywhere you are in the process of getting your legal needs met, and we practice in areas of wills, trusts, and estates, which is estate planning, business and contracts, family matters, real estate matters, and expense.
So, hi, I'm Ajane, and to get things started, we're going to start off with the estate section. By the end of this section, you'll know why estate planning matters, what's required, and what options are available to you, and how you begin to plan. So, the most common form of estate plan is no plan at all. This is what becomes intestacy. We'll talk about that shortly. Estate planning is a necessity. Although many people don't prepare, preparing is an absolute need. It's the only chance that many people get to make decisions for their future self and their loved ones. You can be as detailed and specific as you like, or you can just be broad and open. It's how you can ensure that your wishes are known and followed. If you have a large estate, it can help you prepare for estate tax avoidance, and it can prevent many other issues such as the heir property cycle, and it is customizable based on your unique family situation. Now, there are different types of estates. Probate property and estates are subject to creditors' claims. These are the type of estates that you usually think of. So when you make a will, although you're putting your needs out there and letting it be known, it still has to go through the court process of the probate administration. Intestacy, as I mentioned, is when you have no plan in place at all. This will require that your probate property pass by the laws of your state. So in North Carolina, based on the general statutes. Non-probate property is usually not subject to creditor claims. However, it can become so. So this is your contract type of estate planning. So your life insurance policies where you decide how your proceeds will pay out at your death. These are joint properties. But to be more specific, this is when you have a joint property with a right of survivorship. It usually does not go through the probate process in almost all cases because the person who survives you automatically gets your portion of the property. And then designated accounts. This is what most people know as a payable upon death type of bank account. And then there are trusts. A key point is that a trust has to be in existence before you execute your will. If you're going to mention in your will, I want everything to go to a trust. Otherwise, you still have to go through the probate process, and it is just as complicated as if you didn't have a trust set up at all. So for more detail about the probate estates with regards to intestacy, this is the statutory estate plan. And in North Carolina, it goes out to 5 degrees of kinship. Generally, most people are looking at what happens if you're a spouse. So this is a key point where estate planning and family law overlap. You're considered to be married until there's an absolute divorce that has been signed by the court. So although you all may be married, but you haven't lived together or you've been separated for several years, if you are not legally divorced, you all are still married and your spouse is still entitled to your real and personal property. So this is kind of detailed, but one of the main things to know is that through intestacy, the surviving spouse only receives the entire estate of the decedent, who is the spouse who passed away. If the decedent does not have parents or any lineal descendants. And those lineal descendants are children, grandchildren, and such. So if you have parents or children, the surviving spouse does not automatically receive your entire estate. This could be an issue for people, especially if they may not have a relationship with their parents, but they have parents who are alive. And also, this is usually not what you would want. You wouldn't want for your parents or, necessarily descendants to get things outright if you're married. So if that is your wish, you should consider having a will at the bare minimum. Now, the next type of probate estate is wills. Wills do not require very much or a high level of capacity to be able to be legal. Many people try to make wills themselves. While a holographic or handwritten will is allowed, you still have to comply with what the law requires. So these requirements are that the person who makes the will is 18 or older. They have testamentary intent, which means that they understand that at the time that they are creating the will, that the will is to be for the purpose of deciding how their property will go upon their death, and that the person has testamentary capacity at the time that the will is executed. So this means that the person understands the natural objects of their bounty, the kind and nature and extent of their property, and the manner that they want their acts of the will to take effect. And they also realize that the effect of the will is to distribute property at death. So really what that just means in a more simple way is that the person is over 18. They understand that they're making a will to distribute the things that they own. They know what they own, and they know who is entitled or who they want to have their property. Now, I mentioned that you can handwrite a will if you'd like, but there are several things that you want to be mindful of. The testator, so the person creating the will, must sign the will, and it has to be in the presence of 2 witnesses. So even if you handwrite it and you put it away, it's not valid. You can comply with everything else. You can type it up and comply with everything else. But if you have not done this in the presence of 2 witnesses who also sign the will, your will is not valid. Now, it's not required that the will is notarized, but it is highly recommended to have your will notarized, especially if you create it on your own. And the notary is going to notarize the testator's signature as well as their witnesses. If the will is not still proved through the notary process, the witnesses will need to testify to the clerk about the writings and the circumstances of the will's execution. Another key reminder is that the witnesses should be disinterested. That means the witnesses should be people who are not going to take under the will or who would not likely be heirs under the rules of intestacy. So if you are signing a will, your husband or wife or child should not be a witness. You should look for a friend who you're not planning to leave anything to, or a coworker, or even a stranger. Wills are not necessarily set in stone. They can be modified. And when they're modified, they get republished. So with the new date. So you can create a will in 1930. That will is going to last. But if you make modifications, then the new date, so it could be in 2020, that is the new date of the will. So with regards to that, you have to remember that any changes that you make to your will has to be executed the same way the will was executed. So if you had a notary and 2 witnesses, you need to have a notary and 2 witnesses when you make changes to your will. Now, you can revoke a will in writing by saying that you revoke the will. You also, when you do that, have to make sure that you have the notary and two witnesses. You can do it by physical acts such as throwing the will in the fire or tearing it up and shredding it, or by the operation of law. So when you're divorced, most of the time, the court is going to go ahead and strike anything that's given to a spouse. As we mentioned, once you're divorced, that is when you are no longer spouses. So if you left everything to your spouse in your will when you all were married and 20, 30 years go by and you all are now divorced and you hadn't changed your will, that spouse will not receive under your will. And usually, unless you make something else, it'll go by intestacy then. And a will can be revived if you've revoked it, but you would have to go ahead and create a new will and mention the fact that you're reviving your old will. And then you can also have a pour over will, which is when your assets go into a trust when you pass away. And the trust can be created in the will, but as I stated, remember, if you create the trust in the will, then at that time, the trust will have to be subject to probate. Otherwise, if the trust is created and executed and funded before the will is executed, then it can bypass the probate procedure. Now, we mentioned the non-probate estates. These are a little easier and less complicated to understand. So, as I mentioned, things that are based on the operation of a contract, so your retirement accounts, those have a beneficiary and contingent beneficiaries oftentimes. Same thing as your life insurance policies. You have the payable on death beneficiary accounts and other beneficiary designated accounts. And then by the operation of law. So those are the things I mentioned where you have the joint tenancy with right of survivorship. So this is when one person who owns the property and they own it together, one of the two people passes away, the other person automatically owns the remaining property. So it can be a house, it can be a business in some cases, it can also be a bank account. A lot of times that's how your bank accounts when they're joint are titled. Also has tenancy by the entirety. It's all the same things as its joint tenancy with right of survivorship, except for the fact that the two people who are a party also have to be married. So now let's just go into trust. So trust, as I mentioned, can be created at life or at death. If it's at death, it's done through a gift to a trustee or by designating the trust as a beneficiary. It can be for life insurance proceeds or other death benefits. The owner of the property declares that the trust is owned by the trustee. So you can retitle the property in that way. The requirements to make a trust are that the settlor has capacity to make a trust. The settlor has the intention to make a trust, and that the trust has a definite beneficiary, or it must be a charitable or a pet trust. Yes, you can make a trust for your puppy. Now, trustees do have duties to perform, and they cannot mingle their assets with the trust assets. Trusts can be revocable or irrevocable, where they can be modified or terminated in different ways. Irrevocable trusts can only be modified or terminated by the consent of the settlor and all beneficiaries. Creditors cannot reach the assets in a trust if it's a spendthrift trust, a discretionary trust, or a protective trust, unless it's for a domestic obligation. The trustee has broad powers, and they have the duties to act with good faith and loyalty. They must manage the assets prudently, and they must be fair towards the beneficiaries. But to hold a trustee accountable, they can be sued by a beneficiary or even the settlor if they breach any duty. Other things to consider when you're doing your legacy plan is the power of attorney, your healthcare power of attorney forms, the living will, and guardianship for minors or relatives that you take care of who may have disabilities. So the durable power of attorney is effective at execution, and it can be revoked if necessary. So you can revoke it in writing if you have the proper capacity. Healthcare power of attorney, the principal, who's the person making the power of attorney, they have to have the understanding and capacity to communicate their healthcare decisions. And they have to be 18 or older. The agent also has to be 18 or older, and they cannot be the person who's providing healthcare to the principal for pay. So if you have a home health aide, she cannot be the person who's your agent acting under your healthcare power of attorney. When the principal passes away or the agent passes away, the healthcare power of attorney terminates. And it becomes effective whenever a designated person determines that the principal no longer has capacity and understanding to communicate their healthcare decisions. And this can be customized when you complete the document. The same goes for your power of attorney. You can customize the things that the person who is acting as your agent is allowed to do. A living will is when you get to decide whether you want any extraordinary measures taken, how and when you would like things to be handled in that event. And now these are just a few other special topics in estate planning before we get over to our business planning section. Heir property. These are things that you want to think about. So this is a generational cycle. It's time extensive, and it helps to have an estate plan to preserve your family wealth. So a lot of times you hear about family may have land out in the country or in a rural area where it's passed through for generations and generations and generations. But it's just passing, not by way of a will or a trust or anything along the lines of that. It's just because someone passed away and went down to their kids, and now it's getting all divided, and so many people have a stake in the property. But the property is usually not really getting used, and the benefit is not being received by the people that the property was intended to enrich. Another thing to consider when you're creating your legacy plan is equitable adoption. So this is usually when you have some kind of informal situation where you may raise another person's child. So there are requirements for equitable adoption to be recognized. Adoption itself is a legal proceeding, and it is created by the statutes of the state. However, equitable adoption is created by someone acting, as I stated, informally. So the requirements for an equitable adoption to be recognized are the express or implied agreement to adopt a child, the parents, birth, and adoptive, as well as child, relied on that agreement. There's performance by the natural parents of the child by giving up custody of the child. So that's physical custody. And that the child lived in the home of the foster parents and acted as their child. And also the foster parents took in the child into their home and treated the child as their own. And also this takes place when the foster parents do not have an estate plan in place. So in this time, this is when a child who was raised by a couple, so the child could be Anna, and she was raised by Jim and Jane. Well, Anna was given to Jim and Jane by her biological parents when she was little. Passed away. Under the laws of intestacy, other family members would have received the property that they would have more than likely intended for Anna to receive. But because she never was formally adopted, without being able to prove equitable adoption, she would be left out and would not receive anything. So if you plan for your estate and for your legacy, then you can make sure that Anna is treated just as any other child would have been treated. And then also with speaking about children, you can create guardianship documents where in the event that you pass away, you can decide who would take care of your children. And you have to also remember a key thing that adopted, half-blood, and non-maritable children are treated equally for a mother. So if you're a child of the mom, no matter what, all children are treated the same. So the children don't have to have the same father. If they have the same mother, they're treated the exact same by the law. But for fathers, there are many additional requirements that have to be met. So you would have to check on a case by case basis. Now, another thing to remember is that you can create an LLC or other business entity to title your property for your family. A lot of times this is called a family LLC or a family limited partnership. And that entity will survive any person the property may belong to. This is something that can truly be helpful during the heir property cycle. And now we're going to go over to my partner, Alexia Dominguez, to talk about business planning.
All right, so now we're going to cover some topics in business planning, such as business structures and steps to consider. The first type of business entity is a sole proprietorship, which is the simplest and most common entity. You don't have to do anything additional other than conduct your business to be a sole proprietorship. If you're going to operate your business under a different name, you do have to file, so that would be either a DBA or trade. You are entitled to all profits, and you are personally responsible for all your business debts, losses, and liabilities. So basically, you are your business. You're responsible for obtaining any licenses and permits, even if you don't have to file as or register as a business entity. The business is not taxed separately. You report everything on a Schedule C when you do your annual taxes. You must withhold and pay all income, such as self-employment and estimated taxes. Next is the partnership, which is similar to a sole proprietorship, but this is formed by an agreement between two or more people agreeing to carry on a business as homeowners. You have to register with the state to operate a partnership. And a lot of the partnership and how it conducts its business is based off of a partnership agreement that you and your partner sign. There are different types of partnerships. There are general, limited, and limited liability. And the difference is between who manages the company and who has personal responsibility for the debts and other obligations. The partnership is not a separate entity from its owners, so the profits and losses are divided among the partners and paid by the partners based on the agreement. Each partner receives a share of the profits and losses. The payments are based on the partnership agreement. The partnership itself doesn't pay taxes on its own, but it passes through to the individual partners. Next is the limited liability company, or LLC. This also has to be registered with the state, and it is a business entity that offers limited liability protection and pass-through taxation to its members. So this is a separate entity from its owners. Therefore, the owners cannot typically be held personally responsible for the business debts and liabilities. A tax return for the LLC must be completed if the LLC has more than one owner. Any LLC income or loss, as shown on this return, is passed through to the owners. The owners are called members, and they report the income or loss on their personal tax returns and pay any necessary tax, such as self-employment tax. Depending on the election made by the LLC and the members, the IRS will treat the LLC as either a corporation or a partnership. Specifically, a domestic LLC with at least two members is classified as a partnership for federal income taxes unless it files Form 8832 and permanently elects to be treated as a corporation. And if you do this, you can be treated either as a C corp or an S corp for tax purposes. There are filing requirements, annual filing requirements with an LLC, so you have to make sure to keep up with these requirements and meetings, and make sure to consult with your lawyer and an accountant to make sure you're keeping on track here. And next is the corporation. The corporation is also an independent entity. It must be registered with the state. Again, its debt is not considered to be that of its owners. In a corporation, as opposed to an LLC, you can sell stock to raise money for capital. Corporations are made up of a board of directors, officers, employees, and shareholders. The shareholders receive dividends. And corporation can be either a C corp or an S corp. An S corp is considered a pass-through entity, so you can avoid double taxation. And C corp is the income is taxed at the corporate level, and if dividends are distributed at the individual level as well. You start off as a C corp, but you can apply to be an S corp with the IRS. All right. And next, you have to consider the pros and cons of what would benefit you and your business. So consider any startup filing costs and requirements. Like we mentioned, for the sole proprietorship, you don't have to file or pay anything unless you're doing business under a different name, in which case you would register that trade name. Consider the liability on yourself and your partners, if you have any. Consider the type of control you want to have. For example, with a corporation, there's more people involved. You have a board of directors, you have members, you have shareholders. Consider any tax implications and how you want to handle that, and any annual requirements such as meetings and filing requirements. And also consider if you want to have the ability to raise capital. For example, if you do want to do that, you would go with a corporation. But remember, you can start off as one business entity and then transition to another depending on your needs. Again, you might want to speak to a tax professional or a CPA about specific tax situations and any questions you may have. So next are just a few tips on how to form a business. First, we recommend making a business plan. Really know what business you're getting into, who are your target clients, what it is that you want to be doing. Then decide on a business entity name. Draft any governing documents such as operating agreements, partnership agreements, anything that you may need. Plan ahead with buy-sell agreements. What's going to happen if you have a partner and you can't agree on something, who's going to be the person that has the last word. Follow appropriate paperwork if necessary. So if you are doing an LLC or a corporation, make sure you register with the state and make sure that you're keeping up with annual requirements. Obtain a tax number and EIN if you're going to have any employees. Keep up with, So if you have any questions about any of this, whether it be estate planning or business planning, anything like that, feel free to reach out to us at www.smithdominguez.com, set up a consultation with us, and we're more than happy to help you.